Hi, everybody. This is Michael Blake, patent attorney with the law office of Michael A. Blake in Milford, Connecticut. And this talk will be about intellectual property basics for small businesses. So many people who own small businesses really don't know much about intellectual property. It seems like kind of a very esoteric term, and I'm going to try to explain it so that it's easily understood. And many people in business think, how do I protect my idea? I don't want someone else to steal it and make money with it. So today I'm going to try to answer that question. How do you protect your idea? Well, there's different types of intellectual property protection. The first one I'm going to talk about is patent protection. Patents don't protect ideas. Patents protect inventions. What's the difference? An idea might be something that's you're thinking about to solve a problem, to improve some condition or some business issue. But you really haven't done any work to make it or build it or figure out how this idea will work. You haven't really enabled it. An invention, though, you've done some work where you may have built a prototype, but that's not necessary. But you may have thought about it and figured out, oh, okay, I can take my idea, go to Home Depot, buy some lumber and fasteners like nails and screws and build this thing. Not actually build it, but you figure out how you would build it, and then your idea becomes an invention because you've at least thought about how this thing can be built and how it works. So patents protect inventions, and you have to file a patent application, generally in the United States Patent and Trademark Office. And it takes anywhere from 6 months to 2 years before your patent application will issue into a patent. And once you have a patent, then you can sue or threaten to sue other people for infringing your invention, for copying your invention and making and selling it. Okay, so that's the first type of intellectual property that I just discussed. The second one is trademarks. Trademarks protect words, phrases, and logos, generally. And they identify the originator of a good or service. So again, a trademark does not protect an idea. It protects the brand name of your good or services, or the brand logo of your good and services. So something like the Nike swoosh is a trademark for Nike products, such as their athletic shoes and clothing. The Roto-Rooter Man is a logo for plumbing services. Coca-Cola is a famous trademark for soda pop. So trademarks protect words, phrases, and logos. You don't have to file a trademark application to have trademark rights. Simply using your trademark in commerce starts your trademark rights. If you file and get a registered trademark, then you have some additional rights. And that registered trademark can add value to your company or business. It's an asset, an intellectual property asset that your company owns, and so that could help increase the value of your business if you ever want to sell it. Okay. The next type of intellectual property is copyright. Copyrights protect creative works, which can include things like photographs, paintings, drawings, written works like novels, poems, architectural works, sculptures, even choreography. So that's another type of intellectual property protection. Again, similar to trademarks, you don't have to register a copyright to have copyright in your creative work. Basically, in the United States, the way the law works is once you set your creative work in some sort of tangible medium, you have automatic copyright. And the tangible medium could include computer memory. So if you write a short story on your computer and save it, then you have automatic copyright. The next type of intellectual property I'm going to talk about is trade secrets. Trade secrets can protect many things, including ideas. That's one of the only ways I know of. Well, one of the few ways. The next way I'm going to talk about also could protect an idea, but a trade secret can protect an idea. Trade secrets can protect your inventions. It can protect your customer list, the way you do business. You may have procedures. Your recipe for a fried chicken. Colonel Sanders' Kentucky Fried Chicken recipe is a trade secret. Same with the Coca-Cola recipe for making their soda water. And a trade secret you protect by keeping it secret, basically. You have to have procedures in place at your place of business to keep secret those things that you want to be considered a trade secret. And generally, there's no sort of registration required for that. The next way to protect your ideas is with non-disclosure agreements or confidentiality agreements. This also can protect ideas, and just about anything else you can put in the agreement. So NDAs is short for non-disclosure agreement. If you can have someone sign an NDA, then you could disclose your idea to them. And if the NDA talks about that idea as being the protectable subject matter of that non-disclosure agreement, the party you disclosed your idea to is required under that contract not to disclose it. So that's another way to protect an idea. NDAs can also protect inventions, all sorts of things, ideas, ways of doing business. And again, there's nothing you really have to register or file with any government entity. You just create the NDA, usually with a lawyer, and have the other party sign it, and the other party under that contract agrees not to disclose your idea or whatever is the subject matter of that NDA. So those are the ways to protect your intellectual property: patents, trademarks, copyright, trade secret, non-disclosure, or confidentiality agreements. I hope this helps. Thank you.